Committee members, departmental officials, I call this meeting to order. Welcome to meeting number 96 of the House of Commons Standing Committee on Human Resources, Skills, Social Development, and the Status of Persons with Disabilities. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person and remotely using the Zoom application. Today, everybody is attending in person. I would like to make a few comments for the benefit of all the participants. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the mic since nobody is doing. Interpretation for those in the room. You use the earpiece that you have. Select the official language of your choice. Interpretation services will be provided. You have the option of speaking in the official language of your choice. If there is a problem with interpretation, translation, please get my attention by raising your hand. We'll suspend while the issue is being clarified. For the benefit and the protection of the translators, I would advise you to please keep your earpiece away from the microphone, as well as make sure your telephone is not on vibrate, being close to the mic, because it will cause an issue with the translation. Again, I remind you to direct all comments through the chair. Pursuant to the order of reference of Wednesday, September the 20th, 2023, the committee will begin the clause-by-clause consideration of Bill C-318, an act to amend the Employment Insurance Act and the Canada Labour Code, adoptive and intended parents. I would like to provide members of the committee with some instructions and a few comments on how the committee will proceed with the clause-by-clause consideration of C-318. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the bill and in the package each member received from the clerk. Members should note that amendments must be submitted in writing to the clerk of the committee. The chair will go slowly to allow all members to follow the proceedings properly. Amendments have been given an alphanumeric number in the top right corner to indicate which party submitted them. There is no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. During debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will consider and vote on the preamble, the short title, the title, and the bill itself. If amendments are adopted, an order to reprint the bill may be required so that the House has a proper copy for use at report stage. Finally, the committee will have to order the chair to report the bill to the House. That report contains only the text of adopted amendments as well as an indication of related clauses. We have appearing with us this afternoon witnesses from the Department of Employment and Social Development. We have Madame Nandi, Director General, Employment Insurance Policy Skills and Employment Branch. Madame Field, Executive Director, Employment Insurance Benefits Processing. Sojin Yu, Director Special Benefits. Magali Magali Brochu, Manager Special Benefits, and Neil Buron, Manager Strategic Policy and Legislative Form. We will now move to pursuant to Standing Order 75-1, consideration of the preamble is postponed. The chair, the chair, calls Clause 1. Clause 1. Ms. Gazan.
Yes, no, thank you. I'm a visitor at the committee, so I know that you've spoken and reviewed these amendments prior. Are we at 1.2? Is that right? 1.2? No?
Sorry, Ms. Gazan, no, the committee did not meet and review the
Okay, we did not.
No.
Okay. So are we at 1.2 though? Is that right?
Correct. Yes, 1.2.
Okay, 1.2.
Yes, and there is an amendment, NDP 1.
Yes.
Do
So
you wish to move the amendment, Ms.
yeah, I
Gazan?
wish to move the amendment.
You have
So
the floor.
thank you. So, you know, I feel like it's like the Twilight Zone. I'm back here again having to justify why these amendments are relevant in terms of being able to amend the bill. We'd like to change it for greater certainty in this part, a reference to the placement of one or more children with the claimant for the purpose of adoption includes a situation in which one or more Indigenous children are placed in accordance with the customs or traditions to which they belong with the claimant other than their parent for the purpose of giving the claimant primary responsibility for providing their day-to-day care. In the last Parliament, we passed Bill C-15, which meant that all legislation going forward has to be consistent with the United Nations Declaration on the Rights of Indigenous People. And I'd like to read on the record specifically paragraph 8 of the preambular paragraph in Bill C-15, which states the following: whereas the implementation of the declaration must include concrete measures to address injustices, combat prejudice, and eliminate all forms of violence, racism, and discrimination, including systemic racism and discrimination against Indigenous peoples and Indigenous elders, youth, children, women, men, persons with disabilities, and gender diverse persons, and two-spirit persons. I'd also like to refer to preambular paragraph 18 of Bill C-15, which states that whereas the declaration is affirmed as a source for interpretation of Canadian law, which we knew well before Bill C-15, so moving on, but Article 5 of Bill C-15 speaks specifically to consistency. It says, the Government of Canada must, in consultation and cooperation with Indigenous people, take all measures necessary to ensure that the laws of Canada are consistent with the Declaration. I want to start out first by commending MP Falk for putting forward this bill, working with stakeholders who pushed to get this bill forward. One of the areas stakeholders were concerned with, not including, was kinship and customary care, something that I know MP Falk and I had an opportunity to speak about before, and something that is critical. And I'll give you a couple of reasons why before I refer to the United Nations Declaration on the Rights of Indigenous Peoples and how not only this bill is not consistent with Bill C-15, but it also does not uphold the United Nations Declaration on the Rights of Indigenous Peoples, particularly Article 19, 21, and 22, which I'll read onto the record. 90% of all kids in care in Manitoba are Indigenous. There are more kids now in child welfare than at the height of the residential schools. There is no secret about it. The fact that we're even debating this fact that this falls out of the scope, when we passed Bill C-15 in the last Parliament, is disturbing to me, quite frankly, when we know that almost all kids in care in this country, over 90%, certainly in my province, are Indigenous. If you look at Articles 19 of the UN Declaration, I'm going to read it onto the record. A state shall consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions. This includes child welfare institutions, in order to obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. Article 21 states that Indigenous people have a right without discrimination to improvement of their economic and social conditions, including inter alia in the areas of education, employment, vocational training, and retaining housing, sanitation, health, and social security. States shall take effective measures and, where appropriate, special measures to ensure continuing improvement of their economic and social conditions. Particular attention shall be paid to the rights and special needs of Indigenous elders, women, youth, children, and persons with disabilities. We know the child welfare system is a direct pipeline into murdered and missing Indigenous women. Article 22, particular attention shall be paid to the rights and special needs of Indigenous elders, women, youth, children, and persons with disabilities in the implementation of this declaration, something that this bill in this current iteration does not do. I want to commend other parties in the House that understood the importance of ensuring that Bill C-15 was compatible with the child care legislation. Once again, I'm here to talk about the very essence of reconciliation, which is giving our kids back. We need to have decision-making power and the financial resources to be able to care for our kids in the way we choose to care for our kids, which is primarily through customary and kinship care arrangements. Now, in the child care, which is outside of the scope of the bill, in the last time I was in this committee, all members, including one Liberal, voted in favor because they understand that the government has a legal obligation to ensure that all legislation going forward is consistent with the United Nations Declaration. This needs to be amended so it does just that. So I'd like to keep this amendment on the floor. Thank you.
Thank you, Ms. Gazan. As chair, I must rule on admissibility of amendments. My responsibility is to ensure the procedure of the House of Commons that has been adopted by all parties is followed. Before I give a ruling on the amendment moved by Ms. Gazan, I'm going to ask whichever official feels appropriate to speak briefly to the issue of, does C-3118 infringe on C-15?
Thank you,
You
Chair.
heard the concern outlined by Ms. Gazan. Could
Yes.
you briefly address that before?
So thank you, Chair, for the question. Yes, we did hear the brief description of Bill C-15 with regards to the United Nations Declaration of the Rights of the Indigenous Peoples. That being said, we are not here to speak to the content of that particular bill, so it would not be able to make a direct comparison. I will say that in terms of kinship and customary care, the issue is with regards to the temporary nature of those placements, and that's the focus.
Thank you. Procedure that does not allow for debate on the amendment, Ms. Falk, because I have to first rule on if it's admissible before we can go into debate. So at this time, I thank Ms. Gazan for her comments. And as chair, Bill C-3118 introduces a new type of special benefits, an attachment benefit of 15 weeks for adoptive parents and parents of children conceived through surrogacy. The current amendment, attempts to create another benefit where an Indigenous child could be placed with a claimant different from the child's parent, following different processes than the provincial adoption process as stated in the bill. And the claimant could be entitled to obtain a 15-weeks benefit drawn from the Treasury. As House of Commons procedure and practice, third edition states on page 772, since an amendment may not infringe upon the financial initiative of the Crown, it is inadmissible if it imposes a charge on the public treasury, or if it extends the objectives or purposes or relaxes the conditions and qualifications specified in the royal recommendation. In the opinion of the chair, the amendment proposes a new scheme which imposes a new charge on the public treasury and as such would require a royal recommendation. Therefore, I rule the amendment inadmissible. Ms. Gazan?
Well,
Ms. Gazan, there's no debate. You can challenge my ruling.
Right. Yeah, so it's time to give our kids back, so I'm going to challenge your ruling.
Okay, thank you. The ruling of the chair has been challenged. Madam Clerk, I call a recorded vote on the challenge to the chair's ruling. Does the committee support the chair's ruling or not?
So members, the question is, shall the chair's decision be sustained? So that means that if you vote in the affirmative, you're voting to support the chair's decision, and if you vote no, you're voting against the chair's decision. So Mr. Fragiscatos?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Mr. Van Bynen?
Yes.
Mr. Coteau?
Yes.
Mrs. Gray?
No.
Mrs. Falk?
No.
Mrs. Ferrari?
No.
Mr. Aitchison?
No.
Madame Chabot?
No.
Mrs. Gazan?
No.
Yeas pour 5, nays contre 6.
So my ruling on the amendment was defeated. The chair. Members, it brings us to debate. Ms. Falk.
Thank you very much, Chair. And I want to also personally thank MP Gazan for moving this amendment. So I had introduced Bill C-318 to address the current discrimination that exists in our employment insurance program. And so I want on record, because this bill does not explicitly include claimants in a customary care arrangement, it was my expectation that they would have access to it, as is generally the case with the current parental benefit. So I recognize that this amendment will ensure their inclusion, which I believe to be in the same spirit and intent of my private member's bill. So I will be supporting this amendment.
Ms. Ferrari, Mr. Kuzmirchuk.
Thank
Ms.
you.
Ferrari.
Thank you, Mr. Chair, and I want to thank my colleague, Ms. Falk, for bringing this private member's bill, because I think when we look at equity, that's what really this comes down to. That's what this bill is all about. A parent is a parent and a caregiver, and it's a critical bill, and it's something to be extremely proud of. In relation to Ms. Gazan's amendment of what she's brought forth, I can't stress enough how vital this is. And we have worked together on C-35, which is the child care bill, and we've worked together on the status of women. And when this was put forward in C-35 to support the rights of Indigenous parents, and the Liberals voted against that, we saw this again, and it just doesn't make sense. So I sense her frustration greatly today. I can feel it from her. And I think if we want to have a great country, we have to have healthy kids, and kids need to be cared for. And this is a no-brainer amendment, and quite frankly, I'm shocked, especially when you have the person who has put forward the bill to say, yes, this is well within the scope of what she had hoped for. So I fully support my colleague, Ms. Gazan, today, and I would deeply encourage, as we see articles after article come forward in the news about this marketing slogan of $10 a day childcare crumbling in each province because the feds, the Liberal government, did exactly what we said they would do. They set the provinces up to fail. And you know who's losing? Children. So I just want to bring it back because this is what this all comes back to is parents having choice, parents having flexibility, however you choose to have a child. And I just want to fully support my colleague, Ms. Gazan, today with this amendment.
Thank you. Mr. Kuzmarchuk on the amendment.
Mr. Chair, can I just ask for a 5-minute suspension?
Sure. We'll suspend for 5 minutes. Suspend. resuming, when the committee suspended, there was discussion on the amendment NDP 1. Any further discussion on amendment NDP 1? Mr. Kuzmarchuk.
Thank you, Mr. Chair, and I just wanted to begin by just thanking the committee for bringing this debate forward, 318, and I wanted specifically to thank the MP for Battlefords Lloydminster for her work in bringing this study forward. And I also wanted to say thank you to all the witnesses that testified, and also wanted to say really thank you just to all the parents, all the adoptive parents, again, and their incredible love and their incredible commitment that they demonstrate. And I believe that the discussion that we're having here and the government bill that will be coming forward as well too, has already been tabled under Bill C-59, recognizes that selflessness, recognizes that commitment, and recognizes that love of adoptive parents. I also wanted to thank my colleague, Ms. Gazan, as well too, for bringing this very thoughtful amendment forward. And we want to make sure, we want to do everything possible to make sure that that our federal laws and policies that we bring forward, not only that they align with UNDRIP, not only that they are consistent with UNDRIP and our responsibilities under UNDRIP, we want to make sure that our policies, we want to make sure that our programs and our laws also reflect the priorities of First Nations, Inuit, and Métis people in our country. And this is an important amendment that was brought forward, and I believe it's an amendment. That ought to be studied further. It requires, I believe, additional research, additional thoughtful conversation, and above all, it requires careful and considerate consultation with First Nations, Inuit, and Métis across Canada. This is important, and obviously children are at the very center and heart of the work of this government. And so for that reason, I do believe that there are questions about this amendment that need to be answered. There is information that needs to be brought forward, and I believe that there ought to be a process in place where that information can come forward to members of this committee, but also to members of government as well too, in designing these policies. And so I do believe that we are skipping an important step here of consultation, first and foremost, deliberation, and also information. And so for that reason, I will be abstaining from this voting on this amendment.
Thank you, Mr. Kuzmarchuk. Madame Gazan, you had your hand, and Madame Shabbat.
Thank you.
Amendment.
Thank you so much for your feedback. A couple of things. This is not a choice when Bill C-15 became law. It's a legal obligation for MPs to make sure that it's consistent with Bill C-15. So I don't think we're doing anybody any favors by not upholding the rule of law today, full stop. On the matters of customary and kinship care, the fact that the government still needs to consult when there is ample evidence, something that the Liberal government has said they support the national inquiry about issues around the child welfare system, the fact that Indigenous leadership have been very clear across the country that we need control over our own child welfare systems, which include customary and kinship care, as a main form of keeping our kids within our communities. We know that certainly in my communities, kids are aging out of care and being dropped off at the Salvation Army. One only has to look at the impacts of the 60s scoop when kids were taken out of their families and communities, shipped off into other places, what that looks like in our communities today. And I'll tell you what it looks like. It looks like a whole lot, thousands of people living with complex mental health and trauma being adopted out and having to live in families where they suffered the most outrageous abuse, something that this government hasn't even looked at yet. This is an opportunity for the Liberal government, alongside all parties, to unanimously support the human rights of Indigenous kids in this country. And once again, I'm in committee, and that is not happening. Child welfare is a pipeline to the justice system. Child welfare is a pipeline to become murdered and missing men and boys, murdered and missing Indigenous women and girls. The fact that we have an opportunity to uphold our legislative duties, to uphold the Constitution, which now includes C-15, and we are using consultation as an excuse, shows the normalization of violence against Indigenous people in this country that has been perpetrated through systems, and I would say at the very worst, through child welfare systems. This is why lead advocates leading this bill called for the inclusion of customary and kinship care. So abstaining is silence. It's saying, I'm going to stay silent to violence against Indigenous kids in this country. It's time we get our kids back. I'm glad, yes, violence against Indigenous kids in this country, because the kind of violence that kids undergo in the child welfare system, the stories that you hear in terms of the way the system has failed our kids, including my own family and my mother who grew up in child welfare, we have an obligation today to do what's right. And I am asking everyone at the table, I have the votes, to show a true act of reconciliation. That's what I'm asking for, in honor of the kids that have been lost in systems. I'm asking for your courage today to not abstain. So I'm going to leave it at that. But I wanted to share that because that is how critical this amendment is. And I'm glad that the Conservative folks around the table and the Bloc, along with the NDP, understand the critical nature of these amendments when we're talking about anything related to child welfare. Thank you.
Thank you, Ms. Kazan. Madame Chabot, on the amendment.
Merci, Monsieur le Président. D'abord dire
Thank you,
que
Mr. Chair. I think are all being invited to vote in favor of this bill, which aims at recognizing equity for all adoptive parents alongside biological parents. I don't think that's the only equity that we're looking for. There's also employment insurance, but that's another issue. And I think it is clear that adoptive parents especially need to be treated fairly. And hopefully this will lead to adoption. And in Quebec, this has been in place since 2021. So when it comes to equity, we should not hesitate to support this bill. And I agree with the amendments put forth by Ms. Kazan, by the NDP, which, beyond all of the examination of the studies that we have done, I think the aim is to say, well, let's take into account in the principles underlying this bill before us of the cultures and the traditions of the group regarding children who are the subject of a placement. That is the spirit of this bill. Certainly, yes, it could lead to the recognition that based on customs and traditions, that those who take in a child that is not their own can benefit from the benefits that are available to them. I think it's a matter of principle here. And in my mind, it seems to me well worded in all of the sections where this applies. And I completely agree with this. But I don't think that this would require another committee to study the pluses and minuses of this. I would like to speak in favor. Thank you.
Madame Chabot, Ms. Falk, on the amendment.
Thank you very much, Chair. The substance of the amendment that we are debating right now is to ensure that kinship and customary care will be added to this bill. I find it very frustrating when MP Kuzmaricek makes the accusation that consultations weren't done and that they weren't completed and the committee didn't hear. I've met with many stakeholders in drafting of this bill. We had many witnesses come here also and testify. But to use the excuse of an abstention due to the lack of consultation, does that mean there was no consultation put into C-59? That would be my question. We're voting in favor for this to ensure that it is put into C-318.
Mr. Coteau, on the amendment, and I would remind members to speak
Yeah,
to
it's on
the
the
amendment.
amendment. I just have a question to the member opposite whose bill we're discussing here. Like, did you consider putting this in before, this amendment? Like, when you consulted with the Indigenous community, like, why were they excluded from your bill? Like, and specifically around
I think
the
the chair
kinship
gave me the
piece,
floor.
yeah.
As I maybe the member wasn't listening when I took the floor the first time, just to address MP Kazan in thanking her for doing this. They weren't intentionally left out, Indigenous people. The way that I assumed that this would happen is that they would have access to it as they generally do, This is something that's going to solidify it, to make sure that nothing gets missed on the regulation standpoint.
Mr. Coteau, on the amendment.
Yeah, I've been involved in crafting legislation for child protection. Like, it was a 250-page document in Ontario when we wrote the entire Child Protection Act, and it took several years to get to that point. My concern here is that there's and a member knows opposite. I'm very supportive of the Indigenous community and many of the pieces that she's talking to. My problem right now is that I feel like this is a last-minute attempt to fix something that fundamentally doesn't really cover what, a comprehensive issue that deserves more attention than this. To miss out completely on the Indigenous community and last minute throw them in with an amendment rather than building a comprehensive type of piece of a bill. It worries me that what else is missing here? What else is being left out? So I'm personally not going to support this, mainly based on the fact that I don't think it does justice to the Indigenous community. And as a last, and I respect the member opposite who's made the amendment. I think that's the right thing to do. But I don't have confidence in just last minute putting this in without really going out there and listening to the community. They've been completely ignored in this bill if they're not included in it. It's kind of I think it's insulting to the community, to be honest. Thank you.
Ms. Kazan, on your amendment.
So again, respect, but here's the thing. There's been lots of research, documentation, publications by Indigenous child welfare agencies supporting the need for kinship and customary care. What's missing is that often family members or kinship and community have to take on this responsibility with zero income. You find me an Indigenous person, you talk about disrespect, I'll tell you what's disrespectful to Indigenous communities. From my perspective, only speaking as one Indigenous person, is that we have to consult about stupid stuff like, do we want toilets? How do we feel about clean drinking water in our community? You ask one First Nations community who doesn't want to have control over matters that impact their kids in a way that is consistent with our customs and traditions. You find me one. This is at the very foundational level of the TRC. One of the worst things they did was they stole our kids and they criminalized us as parents. The state did that. And now the state continues to do that through the child welfare system. The only people who are wards of states are kids in child welfare and people that are incarcerated. And for most kids in care, it is like a lifetime incarceration that leaves lasting identity issues and lasting issues. We cannot risk children having to be taken away from family and community for issues of poverty. which sometimes result in kids going into care, not lack of parenting, but issues of poverty. So the consultation piece, not doing Indigenous people justice, doesn't fly, which is why I put forward this amendment, which is what we're supposed to do in committee, is that people put forward legislation, even in parties not of my own. And my job as a legislator is to put forward amendments to strengthen legislation. Yeah. And I can't like, you know, in all respect, I know change is hard and I mean this. But like, when are we going to be brave enough to just, you know, honor human rights without question and qualification? And I'm hearing questions and qualifications, and now it's consultation. That does not fly, especially with what has been said loud and clear from leaders in our community, including our women. So I'm going to leave it at that. I don't mean to sound like Martin Luther King. I'm not trying to, but like, this is our kids. And if the government is too scared to give our kids back, when are we going to reconcile in this country to give us what we need to look after our kids? So I'm going to leave it there.
Seeing no further discussion on NDP 1, the amendment, I will ask for a vote on NDP 1, the amendment to clause 1.
Mr. Fragiscaros,
Abstain.
Mr. Collins,
Abstain.
Mr. Van Bynen,
Abstain.
Mr. Long,
Abstain?
Mr. Coteau, Mrs. Gray,
Yes.
Mrs. Paul,
Yes.
Mrs. Ferrari,
Yes.
Mr. Aitchison,
Yes.
Madame Chabot,
Oui?
Mrs. Gazan.
Yes.
6 yeas, 0 nays.
NDP 1 is carried. Shall clause 1 carry as amended? Carried as amended? Clause 1's carried as amended. The following clauses had no amendments, so with unanimous consent, we can group them. It's Clause 2, Clause 3, Clause 4, Clause 5, Clause 6, and Clause 7. There was no amendments received on those clauses. So with that, I would call for the adoption of Clause 2 to 7. Shall clauses 2 to 7 carry? Yes. Carried. Clause 8. Clause 8, we have an amendment. NDP 2.
Yes, can I put forward the amendment, Mr. Speaker? Yes, thank
Goes
you.
on. It
Okay.
is-
Want to amend for the exact same reasons to be consistent with Bill C-15. For greater certainty in this part, a reference to the placement of one or more children with a self-employed person for the purpose of adoption includes a situation in which one or more Indigenous children are placed in accordance with the customs and traditions of the Indigenous group, community, or people to which they belong, with a self-employed person other than their parent for the purpose of giving the self-employed person primary responsibility of providing their day-to-day care. And it's for the same reasons that I put forward before, to be consistent with Bill C-15 and the articles that I outlined in UNDRIP.
Debate on the amendment referenced NDP 2. Oh, sorry. Before we get to debate, again, my responsibility as chair is to follow the procedure adopted by the House, which requires me to rule on the admissibility of amendments. Bills again, Bill C-318, as it was presented to the committee and debated by the committee, introduces a new type of special benefits, an attachment benefit of 15 weeks for adoptive parents and parents of children conceived through surrogacy. This amendment attempts to create another benefit, where an Indigenous child could be placed with a self-employed person different from the child's parents, following different processes than the provincial adoption process as indicated in the bill. And the claimant could be entitled to obtain a 15-week benefit drawn from the Treasury. As the House of Commons procedure and practice, third edition states on page 772, since an amendment may not infringe upon the financial initiative of the Crown, this amendment is inadmissible if it imposes a charge on the public treasury or if it extends the objects or purposes or relaxes the conditions and qualifications specified in the royal recommendation. In the opinion of the chair, the amendment proposes a new scheme which imposes a new charge on the public treasury and as such would require a royal recommendation. Therefore, I rule the amendment inadmissible. My ruling is not subject to debate, but can be challenged. Ms. Gazan?
I'd like to challenge your ruling, Mr. Chair. We need to get our kids back.
The chair's ruling has been challenged. I would ask the clerk to call a vote on the chair's ruling.
Members, the question is, shall the chair's decision be sustained? That means that if you vote in the affirmative, you're voting in support of the chair's decision. And if you vote in the negative, then you're voting against the chair's decision. Mr. Fragiscatos?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Mr. Van Bynen?
Yes.
Mr. Coteau?
Yes.
Mrs. Gray? No. Mrs. Falk?
No.
Mrs. Ferrari?
No.
Mr. Aitchison?
No.
Madame Chabot?
No.
Mrs. Gazan?
No.
So 5 yeas, 6 nays.
NDP 2, the amendment is now on the floor for debate. Discussion? Mr. Kuzmarchuk on
Could we just have vote on
amendment.
division?
Pardon?
On division?
Ms. Gazan, you have the floor.
So once again, we are going to have to debate. And you know, I know that there's going to be Indigenous leadership watching this. I know that families and kids that are now fighting for compensation because of the abuse that they experienced in care, or the fact that they're having identity issues because they were brought up away from their families, are watching this right now. And we have an opportunity to do the right thing. We are in different parties, but human rights is a nonpartisan issue. And we can demonstrate an act of reconciliation by voting together today to support a system that has caused irreparable ongoing damage to Indigenous families. Again, there is more kids in care now than at the height of residential schools, something that we always, scoff at. Or the fact that women and girls, men and boys are going missing and murdered. And if you look at the research, most of them spent time in child welfare, away from family and community, because their families weren't given the same resources, financial resources, because this country doesn't recognize the way we care for our children as they didn't during residential school times, which includes kinship and customary care arrangements in our community. So I I know that I'm pretty sure of the outcome, but I just want to bring the point home when it comes to violence in our communities. If you can't take a stand on child welfare, like, you can still do the right thing here. So I'm going to ask everybody here again to please do the right thing and vote for what Indigenous leaders have fought for, which is child welfare reform, so that we don't have to do Jordan Principle settlements where the Liberal government tries to give half the money that is owed as a result of kids in care. So I'm going to leave it there. Thank you.
Ms. Ferrari on Amendment NDP 2.
Thank you. Thank you, Mr. Chair. And I guess I think for people who are maybe trying to follow politics at home, and we're trying to be as transparent and as accountable as possible, and this private members bill that we're debating right now, which was brought forth by my colleague, Ms. Falk, to make it equitable for intended parents and surrogate parents, that they also have access to attachment, meaning EI, which makes total sense. It's a great bill. And then to my colleague's point, Ms. Gazan, when we talk about Indigenous families and kinship and customary care, this is a no-brainer, right, to try to reunite families, right? So I guess my question through her, just the work that she's done, and I worked with her on childcare around this as well, and we were very supportive of ensuring the rights of Indigenous peoples. But why, through you, Mr. Chair, why wouldn't this just be a no-brainer? I'm having a hard time, and if people are watching at home, I guess that would be my question through you to Ms. Gazan, why we would be having comments from the Liberals that there needs to be consultation, or that this is insulting, which has been said today, that this is an insulting amendment, or it's just very confusing, and that they're just abstaining. So that would be my question through you, Mr. Chair.
Your comments are on the amendment. Any other debate? Ms. Gazan?
I don't know. I suspect it has to do with money. And I suspect it has to do with money because if I look at why the federal government was taken for court, it was for deliberately racially discriminating against First Nations kids and child welfare on reserves. So, you know, I'm not quite sure what it is, but I suspect it's money. And the more we keep discriminating, the more money it's going to cost the government, which is why it's important to uphold human rights, which is why I think this is happening.
Mr. Kuzmierczak on NDP 2.
Yeah, thank you, Mr. Chair. And again, I really do appreciate the work of my colleague, Ms. Gazan, bringing this amendment forward. This is an important issue. It's an important issue that we absolutely take to heart. I can tell you that every one of my colleagues at this table takes this amendment and this issue very seriously. But simply put, we want to study it further. We want to understand it better so that we can act on it. We need to understand it. And first and foremost, I do believe that the principle of nothing without us is absolutely paramount. We want to hear from First Nations, Inuit, Métis, here around this committee table and on Parliament Hill on this very issue. And I think it is an important issue. And so our government, it's important for those watching at home to understand that our government is bringing forward a bill that will introduce 15 weeks of EI for adoptive and intended parents. That bill is already in front of the House of Commons in the form of Bill C-59. That bill will introduce 15 weeks of EI for adoptive parents. It builds upon the works of this committee. And there will be an opportunity with the government bill that's moving forward, and hopefully with the support of our opposition members, Bill C-59 will pass the House quickly. Because right now it's facing some headwinds from our opposition colleagues, but we hope to see it pass quickly so that we can get those benefits into the hands of adoptive parents as quickly as possible. That bill will have an opportunity to come before committee, and there will be opportunities for First Nation, Métis, Inuit members to come to Parliament Hill to talk about kinship and customary and kinship relationships, to provide members of Parliament with information, with deeper understanding of what that means and how it fits into this policy EI framework. It is an important issue, and it is so important. We feel that it is so important that we want to hear from Indigenous partners and communities. And there will be an opportunity as this bill is debated at committee, as the Bill C-59 is debated in committee, which contains the EI provisions for adoptive parents. But the principle of nothing without us is paramount, is absolutely paramount. And on an issue as important as this one, we believe that it is absolutely imperative that we hear from Indigenous partners, Indigenous community, and there will be an opportunity to do that as Bill C-59, our government bill that will introduce 15 weeks for adoptive parents, is brought before committee very shortly. And with the help and support of our opposition partners, it will come before committee very quickly. Thank you.
Ms. Gazan, on the amendment NDP 2.
Clearly, there has been lots of consultation on child welfare. You just have to look at the work of Cindy Blackstock. Kinship and customary care is kind of top priority. I find it very patronizing to Indigenous peoples that they think we're so stupid that we have to consult about things that we have been talking about for years, publicly. If you look at any First Nations child welfare agency, if it's now just an issue because I'm bringing it up, maybe it's not, the onus isn't on us. Maybe if people really cared, they'd actually read when they're spending money on reconciliation what's being said. And I know I'm emotional in here, but this is, you know, our kids are dying on the streets. I don't care if you're bringing a bill forward. I have to be honest. I'll sit in committee and I'll make the same amendments to your bill. And if the Conservatives vote against it, I'll say the same thing. You know why? Because this is a human rights issue. Using nothing without us, about us without us. Let me give you examples in real time about how it's nothing, that it's everything about us without us. Including the fact that this government spends nothing on murdered and missing Indigenous women when we're very loud and clear about what the needs are. So please spare me. Like, our kids are dying. So, like, if we're going to make excuses about why we are not supporting the human rights of Indigenous families to have the economic resources so that they have food on the table, then let's just be honest here about where this country's at with reconciliation. But I don't want to hear about nothing about us without us, because I have a whole list of items that are happening without us. But when it comes to our kids, it seems to be a reachable excuse, and that is unacceptable to me. In fact, it's pretty racist. So I'm going to leave it there.
I would again remind members to speak to the amendment. Ms. Chabot, Madame Chabot.
Merci, Monsieur le Président. C'est un amendement que je vais soutenir et être en faveur au même titre que l'autre. Je pense qu'on a 4 amendements. Actuellement, on est rendu au
I would
deuxième.
vote in favor of this amendment. I believe that we have 4 amendments that are all very similar. I'd like to indicate that nobody here around the table is against the principle of nothing about us without us, as nobody here is in disagreement by the necessity of helping persons with a disability. But I'm saying this because there are principles, but the principle of nothing about us without us. Let me give you an example. It's not directly linked to the amendment, but we have the National Housing Strategy for Indigenous Persons. Well, where are we at with that? It's based on a principle, nothing about us without us. But now there's a principle being forward that is for a child according to the customary and kinship care, for a child that is placed for a specific period that will be put up for adoption. Those parents should be able to benefit from 15 weeks I think we don't need to consult for 3 years to come to that. Thank you, Chair.
Thank you. Seeing no further discussion, I will ask the clerk for a recorded vote on amendment NDP 2. NDP 2, yes, NDP 2.
Mr. Fragiscaros,
Abstain.
Mr. Long,
Abstain.
Mr. Collins,
Abstain.
Mr. Van Bynen,
Abstain.
Mr. Coteau,
Abstain.
Mrs. Gray,
Yes.
Mrs. Falk,
Yes.
Mrs. Ferrari,
Yes.
Mr. Aitchison,
Yes.
Madame Chabot,
Oui.
Ms. Gazan,
Yes.
6 yeas, 0 nays.
Amendment. Clause 8 carry as amended. Clause 8 is carried as amended. The next grouping is Clause 9, Clause 10, Clause 11, Clause 12, and Clause 13 of the bill. There has been no amendments received. So with unanimous consent, I will ask for an indication of carrying clauses 9 through to 13 as presented. Seeing no dissension, clauses 9, 10, 11, 12, and 13 carried. Clause 14. And Clause 14, we have an amendment, NDP 3. Ms. Gazan?
Thank you, Chair. Just again, for consistency, 3.3 to be amended for greater certainty in this section, a reference to a child who is in the care of an employee for the purpose of adoption includes an Indigenous child placed in accordance with the customs and traditions of the Indigenous group, community, or people to which the child belongs, with an employee or other than the child's parent for the purpose of giving the employee primary responsibility for providing the child's day-to-day care. For the same reasons, Mr. Speaker, I'm putting this amendment forward.
Thank you. My responsibility as chair is to rule on admissibility of all amendments before the committee. Bill C-318 amends the Canada Labour Code to introduce a new type of special
Et
benefit.
donc, nous allons inviter un nouveau type d'avantage dans le cas d'un transfert d'un enfant adopté ou un enfant né par une mère porteuse, là où un enfant autochtone pourrait être placé avec un employé pas les parents en suivant des processus autres et le processus d'adoption provinciale tel qu'indiqué dans le projet de loi, l'employé pourrait avoir le droit à avoir un congé parental tel que dans la 3e édition à la page 770, un amendement à un projet de loi qui a été
Mr. Chair, I seem to have lost the translation altogether.
Is it translating now?
Vous pouvez continuer, là, mais j'avais zéro traduction.
You may continue, but I did not have the translation at all.
Okay. Do we have? Madame Chabot? D'accord?
That's okay.
D'accord. As House of Commons Procedure and Practice, 3rd edition states on page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, this amendment introduces a new concept that is beyond the scope of the bill, as agreed by the House at second reading, Therefore, I rule the amendment inadmissible. Ms. Kazan?
I'd like to challenge the ruling of the chair.
The chair's ruling has been challenged, which means we go directly to a vote on upholding the chair's ruling or changing it. Madam Clerk, recorded vote on my ruling.
So members, the question is, shall the chair's decision be sustained? So that means if you vote in the affirmative, you're voting in support of the chair's decision. If you vote no, that means you're voting against the chair's decision. Mr. Fragiscatos,
Yes.
Mr. Long,
Yes.
Mr. Collins,
Yes.
Mr. Van Bynen,
Yes.
Mr. Coteau,
Yes.
Mrs. Gray? No. Mrs. Falk?
No.
Mrs. Ferrari?
No.
Mr. Aitchison?
No.
Madame Chabot?
No.
Mrs. Gazan?
No.
Yeas pour 5, nays contre 6.
The chair's ruling has been overturned. Therefore, I will call NDP 3, a vote on NDP 3.
Mr.
Sorry, just a moment. Ms. Kazan?
Do we have room to discuss this quickly?
Yes.
Yeah,
you're-
I'm just going to ask all my colleagues once again to take this opportunity to really support each other across party lines, to support reconciliation in this country as it relates to Indigenous families and children. Thank you.
we're on through. Seeing no further discussion on Amendment NDP 3, I shall call for a recorded vote on NDP 3.
Mr. Fragiscatos?
Abstain.
Mr. Long?
Abstain.
Mr. Collins? Mr. Van Bynen?
Abstain.
Mr. Coteau?
Abstain.
Mrs. Gray?
Yes.
Mrs. Falk?
Yes.
Mrs. Ferrari?
Yes.
Mr. Aitchison?
Yes.
Madame Chabot?
Oui.
Mrs. Gazan?
Yes.
Yeas pour 6, nays contre 0.
Amendment NDP 3 carried. Shall clause 14 carry as amended? Clause 14 carried as amended. The next two clauses, clause 15 and clause 16, received no amendments. So I would ask, indicate if the two clauses can be carried together as presented. Seeing no dissension, clause 15 carried and clause 16 carried. Clause 17, NDP 4, Madame Gazan.
Yes, I'd like to amend this article so that it's just for consistency, 3.3 for greater certainty. In this section, a reference to a child who is in care of an employee for the purpose of adoption includes an Indigenous child placed in accordance with the customs or traditions of the Indigenous groups, community, or people to which the child belongs with an employee other than the child's parent for the purpose of giving the employee primary responsibility for providing the child's day-to-day care. And just to speak to it, I would like to, as I said before, I'd like to find any Indigenous person who would have to be consulted that they could raise their kids in accordance with their customs and traditions of the Indigenous group, why they would need consultation on it. And I look forward to, if the Liberal bill comes forward, if they also did not include custom and kinship care to fight with the same level of intensity. Again, want to give this opportunity to, not abstain, to stand up for reconciliation and kids and Indigenous kids and family in this country and to actually take a stand. I'd like to thank all the colleagues, Conservative, the Bloc, NDP. Human rights are a nonpartisan issue. I welcome the Liberal Party to do the same. Thank you.
Thank you. Before the amendment is brought to debate again as chair, I must give a ruling on the admissibility of the said amendment. Bill C-318 amends the Canada Labour Code to introduce a new type of special benefit to extend parental leave in case of the transfer of a child through adoption or a child born through surrogacy. The amendment attempts to create another benefit where an Indigenous child could be placed with an employee other than the child's parents following different processes than the provincial adoption process that was indicated in the bill, and the employee could be entitled to an extended parental leave. As House of Commons Procedure and Practice, 3rd edition, states on page 770, an amendment to a bill that was referred to the committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, the amendment introduces a new concept that is beyond the scope of the bill as agreed by the House at second reading. Therefore, I rule the amendment inadmissible. Ms. Gazan?
I'd like to challenge the ruling of the chair.
The chair's ruling has been challenged, and Madam Clerk, a recorded vote on my ruling.
Members, the question is, shall the chair's ruling be sustained? So that means if you vote in the affirmative, you're voting in favor of the chair's ruling. And if you vote no, that means you're voting against the chair's ruling. Mr. Fragiscatos?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Mr. Van Bynen?
Yes.
Mr. Coteau?
Yes.
Mrs. Gray? No. Mrs. Falk?
No.
Mrs. Ferrari?
No.
Mr. Aitchison?
No.
Madame Chabot?
No.
Ms. Gazan?
No.
Yeas pour 5, nays contre 6.
The amendment has been adopted by the committee. Is there discussion on the amendment? Seeing no discussion, Madam Clerk, I'll call a recorded vote on NDP 4, Amendment NDP 4.
Mr. Fragiscatos?
Abstain.
Mr. Long?
Abstain.
Mr. Collins?
Abstain.
Mr. Van Bynen?
Abstain.
Mr. Coteau?
Abstain.
Mrs. Gray? Yes. Mrs. Falk?
Yes.
Mrs. Ferrari?
Yes.
Mr. Aitchison?
Yes.
Madame Chabot?
Oui.
Mrs. Gazan?
Yes.
Yeas pour 6, nays contre 0.
Amendment NDP 4 carried. Shall clause 17 carry as amended? Shall clause 17 carry as amended? Seeing no dissension, clause 17 carried as amended. That concludes the clauses. Shall the preamble carry? Carried. Shall the title carry? Carried. Shall the bill as amended carry? Ms. Gray, you're speaking to the bill as amended.
Great, thank you, Mr. Chair. And I just wanted to take this opportunity to thank Mrs. Falk for bringing this important piece of legislation forward. And I hope that everyone can support this bill, including the amendments. So I just wanted to take this opportunity to thank her for that. And also, Mr. Chair, I'm wondering if I can please be put first on the speakers list once we are done with this. Thank you.
Madame Gray, you'll have to get my attention when that time comes. Shall the title carried? It was carried. Shall the bill as amended carry? Shall the chair report the bill as amended to the House? Read. Shall the committee order a reprint of the bill as amended for the use of the House at report stage? Yes. So the committee has agreed, has reviewed the bill, and has adopted several amendments, and the bill will be brought to the House. That concludes the the consideration of Bill C-318, 318. And at this stage, is there other business before the committee? Ms. Gray?
Great, thank you, Mr. Chair. And at this moment, I would like to move the motion, the following motion, which has been put on notice and has been circulated appropriately. That, given that Canada's housing crisis continues to worsen, according to the CMHC, starts on new housing construction were down 7% in 2023, putting Canada further from the 2030 target to restore housing affordability. No housing has been built as a result of the Housing Accelerator Fund. The committee invite the Minister of Housing and the acting president of the Canada Mortgage and Housing Corporation to testify before the committee separately for no less than 2 hours each within 14 days of the passage of this motion. And just to speak on this briefly, the housing situation in Canada has gotten worse since the housing minister and the CMHC CEO were here last. And housing is the responsibility of this committee. And the most recent update from the Bank of Canada's Housing Affordability Index shows affordability is now worse than the 2008 financial crisis and also worse than the mid-1990s. And as a result of the Liberals' inflationary spending, the Bank of Canada still cannot bring down interest rates, further putting mortgage holders in a crisis. Now, the CMHC just reported that there were 7% fewer housing starts in 2023 compared to 2022, and this is more than 17,000 houses less in 2023 compared to 2022. Now, the CMHC's outgoing president told the Senate Finance Committee that there is, quote, no plan at CMHC to build the number of homes needed by 2030 to restore affordability. So this is why we need the current CMHC CEO and the Liberal Housing Minister to come before this committee to answer on the worsening housing crisis and explain how there is no plan to restore housing affordability. Thank you, Mr. Chair.
Thank you. Just before we go, I want to advise the witnesses that you're free to leave because the part of the committee meeting that you were here for has been concluded. So thank you. With that, the motion is in order. Discussion, Mr. Fragas-Catos.
I will seek to amend the motion, Mr. Chair, in light of the fact that the minister has appeared at committee several times and that there is only an interim CEO now at CMHC since the parting of Ms. Bowers, who's gone to the IMF. So in light of those things and the fact that, and I think it's an important fact, there's not enough emphasis in this motion, with all due respect, on affordable housing or co-op housing. So I would amend it so that it reads, given that Canada is in a housing crisis, the committee undertake a study of co-op and affordable housing, that the committee invite the president and CEO of the Canada Mortgage Housing Corporation, once appointed, to testify before the committee for no less than 2 hours. I can repeat if that was too fast.
Can you forward a copy?
Sure.
Yep, to the clerk. If you would forward it, and then I will ask you again to read it slowly into the record.
I will read it again slowly, and then I'll forward it. How's that?
Good.
Just one moment. Okay, here we go.
Printed and circulated.
Given that Canada is in a housing crisis, the committee undertake a study of co-op and affordable housing, period. That the committee invite the president and CEO of the Canada Mortgage and Housing Corporation, once appointed, to testify before the committee for no less than 2 hours, period.
When I get the speaking order, I believe it, but I need that sent to the Yuma inbox, and then we can have it printed and circulated.
We might have to have it.
To committee members, you have the motions been read into the record. Unless it's available in both official languages, we'll have to deal with it as it's presented verbally on the record. Do you have it in both languages?
I don't at this point.
Okay. Well, then the clerk cannot circulate it, but the amendment is debatable. Mr. Fragascatos, you verbalized it. Mr. Aitchison, then I believe, who else had their hand up? Was it Madame Gazan? Madame Gazan? Okay, well, just a moment. So we got Scott, and we got Leah, and then we got Tracy.
Because I want to hear what everybody has to say first.
That's fine.
Including Madame
Mr.
Chabot.
Aitchison, then I have Madame Chabot? Madame Chabot, then Miss Gray.
Thank you, Mr. Chair. I think I'd actually be okay with adding some further analysis of co-op housing. I think it's one of the many tools that should be at our disposal to solve the housing crisis and affordable housing. I guess what concerns me about that amendment is this notion that despite the fact that we're in a housing crisis, the current interim president of the CMHC is apparently not up to the job of coming to talk to us about the issue. Is that the message I'm supposed to receive here? Because I think, the current interim president happens to have, worked at the CMHC for some time. It's not like, he's new to the game. So, I wonder how long should we wait for the new president to be installed? And in the meantime, I guess, is the place just adrift? Nobody at the helm, so we can't really talk to the current president? What's the message that we're supposed to receive by such a strange amendment?
Sorry, no, we'll have to go Madame Chabot and then Miss Gray and then Mr. Fragascatos on the amendment of Mr. Fragascatos. Madame Chabot?
D'entrée de jeu, j'aurais été portée à soutenir.
From the outset, I would be inclined to support Mrs. Gray's proposal, but I do have a question. Beyond the arguments, oh dear, I can hear myself, but beyond the arguments that we could disagree on, fine, we could disagree, but the substance is true. In 2023, we're seeing a drop. We've been speaking about the housing crisis as a priority for all. And in 2023, we're seeing a drop, and no housing has been constructed. That is true. And that's a situation that's existed since 2022. Concretely, nothing has been built. There are agreements, etc. We continue to sign agreements, but there have been no changes. And I would agree to say, and as I've already told CMHC, it's a 10-year strategy. We're halfway through the year with the housing crisis. We're seeing ongoing issues. What do we do? And the motion that you have presented says that we should wait for the new CEO to be appointed. When? When will that occur? How much time do we have to wait? And the idea to add co-op and affordable, that's fine, but I'm trying to understand. And I think I would be less likely to retain that new motion and perhaps come back to the original motion.
Thank you, Madame Chabot. Ms. Gray and then Mr. Fragascatos
Thank you,
on the
Mr.
amendment of Mr. Fragascatos.
Thank you, Mr. Chair. On this amendment, so basically saying that the current CEO of CMHC would not be coming to this committee means that we will, that the Liberals are proposing that that person will never come to committee, that there won't be a representative from CMHC coming to committee. And we don't know when there will be a permanent appointment, which could be after the next election. So basically what they're saying is that they don't want accountability. This is an organization that is responsible for housing. We have new information that I have laid out here that has just been released since we had the CEO of CMHC and the housing minister here the last time. There is new information. And so it is absolutely relevant that we have both of them come here today. And also they've taken out the part about having the minister come, again, to have no accountability of the minister. So basically they're saying, you know, we don't know when anyone will be able to come to this committee to talk about housing. And that's just completely wrong, considering that it is one of the top issues, one of the top priorities of Canadians. Thank you.
Mr. Fragascatos, your amendment.
You know, if colleagues choose to listen to what I've said in a particular way, I can't control that, Mr. Chair. I would share with them a few different things. First of all, if our side was opposed to the idea of hearing from the CMHC, we would have shown that before. But on the contrary, we've backed motions that ultimately brought CMHC here many times already in the part of the session that started in September and ran through to the mid part of December. So there is that to consider. To Mr. Aitchison's point about the interim CEO, I would prefer to hear from a full CEO when they're appointed. That, I think, is not out of place. When will that appointment come? To answer Ms. Chabot's question, I'm not sure when it will come, but I would expect it to come in due course. And when it happens, I think we can have a much more substantive discussion on the issues at hand. And furthermore, if, because I do remember colleagues around the table, including Ms. Kwan, who's been here on previous occasions, she's not here today, but she is the housing critic for the New Democrats, talk about the importance of rent geared to income housing in all of this. If there's a view that suggests that that should be included as well, then I would be open to that. So we would look at co-op housing, rent geared to income housing, emphasizing the importance of non-market housing. All of these things could be taken up in what I think would be a serious and substantive meeting. And I know Ms. Gray comes to this with very good intent and thoughtfulness, but I'm simply seeking to strengthen the motion that was originally put on the table so we can have a better meeting, frankly, and provide stronger recommendations to the government.
Thank you, Mr. Fragascatos. Mr. Aitchison on the amendment.
Thanks, Mr. Chair. We hear what we hear, I guess, is what it comes down to. And what I hear is that that my colleague isn't quite familiar with the fact that the housing situation in this country is a crisis. Yeah. The previous minister wouldn't use the word. The current minister does actually use the word, but his parliamentary secretary isn't seized with the matter, it seems. And so I think that the interim CEO is the interim CEO because they have a certain skill set and knowledge and understanding of the organization and the issues, and that's why they're there. If they're not capable of speaking to committee, then they shouldn't be the interim CEO, I suppose. The fact of the matter is, you know, this is a delay tactic, and I recognize the minister doesn't like the photo ops he gets here. He'd rather them, you know, out around the country. But that's what we're here for, to raise the issues that matter to this country and matter to the people in this country. And this is the most pressing issue our country is facing right now. I'm looking at one of my colleagues here who used to be a city councillor. I was reading about one of his former colleagues in Hamilton, Mr. Collins. The fact of the matter is, I think that this sounds a lot like deflection, and I'm fully opposed to any watering down of this motion, and we need to have the minister here. If we wait for this government to appoint a CEO, a new CEO, a permanent CEO, we might wait forever.
You wish Mr. Van Bynen or Mr. Fragascatus? Mr. Van Bynen?
Seen the circulated motion yet.
We cannot circulate because it was not produced in both languages. It's verbal. I will reread the amendment when we get to that stage. Mr. Fragascatus, and then who had their hand up here?
So I'd prefer actually just to
No,
listen and then,
I was merely going to ask for a suspension for a few minutes, that's all. So, if you
Okay.
wanted to say, if you wanted to. No, I was going to ask for a suspension, and if that's not the case, then I'll keep, I have some other points to make, Mr. Chair.
We'll suspend. No.
Chair's
We'll suspend for 3 minutes. Suspend it. suspended. Attention. Discussion was on the amendment of Mr. Fragascatos. Since then, I have Mr. Coteau, then Mr. Fragascatos, and Mr. Long.
Thank you very much, Mr. Chair. Can we actually hear the amendment one more time, please?
Given that Canada is in a housing crisis, the committee undertake a study of co-op and affordable housing. That the committee invite the president and CEO of the Canada Mortgage Housing Corporation, once appointed, to testify before the committee for no less than 2 hours. And it would remove A, B, and C of the original motion.
Maybe through you, Mr. Chair, to the clerk, can we find out how many times the minister has been here this year or last year?
Have to verify and report back.
Yeah.
She does not have it.
I think it's been about 3 times. Okay, I just wanted to find that out. Thank you, Mr. Chair.
Clerk will report back. Mr. Fragascatos and Mr. Long.
Thank you, Mr. Chair. Again, any amendment that I've put here today, in keeping with amendments that I've introduced previously, and I think I can speak for colleagues on this side, we do so with sincerity. It's not as if we don't think that the motion presented by the Conservatives through Ms. Gray is not substantive. There is some substance there. We're just simply trying to strengthen it to ensure that we have the ability to have a meeting that allows us to formulate recommendations that will ultimately be put to the government through recommendations that are serious and focused. That's the goal. Now, I'm surprised that the Conservatives did not include a focus on affordable housing that's emphasized. The importance of non-market housing, co-op housing, Mr. Chair, all the rent geared to income, all of these types of housing, which many Canadians, thousands of Canadians rely upon, is crucial. In fact, a few months ago, and I think this merits emphasis, Mr. Chair, a few months ago, the Conservative leader talked about co-ops as Soviet-style housing. How someone could describe that type of model in those terms is beyond me. There are hundreds of thousands of Canadians who live in co-op housing. It's an alternative model to housing, a very interesting one, and one that I think can go a long way to alleviating what is a genuine crisis. Mr. Aitchison said that I don't use that word because I'm somehow afraid to use it. No, that's not the case at all. We are living in a very challenging situation, one that amounts to a crisis. And that's why the government has acted through the National Housing Strategy, where more than 70,000 people, I think last count, who were either on the street or very close to living on the street, now have a roof over their head, quite often with vital wraparound supports that go a long way to ensuring that they make a positive transition, a transition to a meaningful, dignified life. I think that at this committee in particular, a committee whose mandate is quite broad in terms of its reach, but if we're going to achieve anything on those issues and this specific one, housing, then I think we have to find ways to work together. So why a party, the official opposition no less, would dismiss co-op housing as Soviet-styled housing is beyond me. So there is that. On the importance of affordable housing more generally, think about it in these terms: rent geared to income housing, the non-market models that are there. All of this is quite crucial to addressing the crisis at hand. I would like to hear from the CMHC their thoughts on those things. Unfortunately, we won't really have an ability to do that in substantive terms because it's led by an interim CEO now. I'm not sure about you, Mr. Chair, but when I'm trying to get to the bottom of something, I don't want to talk to the interim head of an organization. I want to talk to in this case, the incoming new permanent CEO. That is or if not permanent, you take my point, the new appointment, not the interim leader. I think that is vital if we're going to, again, be serious about the work that we're doing in terms of providing recommendations to the government. And we have a lot of ability at this committee. Mr. Aitchison was just pointing out before the suspension, Chair, about the municipal background of my colleague to my right, who was a city councillor in Hamilton. He himself, Mr. Aitchison, comes from, he was mayor of a community in Northern Ontario, if I'm not mistaken. So let's harness that experience, and those are just two examples. Let's put that experience to good use and ensure that we can formulate recommendations that are truly in keeping with what this committee should be doing. Instead, I find that the Conservatives continue to propose, this is not true of the Bloc, this is not true of the NDP, but the Conservatives in particular continue to propose motions at this committee that won't get us anywhere. The minister responsible for housing has appeared at this committee multiple times. In fact, part of me wants to support the motion of Ms. Gray because in previous appearances, the minister has done extremely well to highlight not just the actions of the government, but the contradictions in the Conservative approach. They want more housing built, but they want to tax builders, for example. They say that they're for affordable housing. They say that they're for different types of housing, but they go after co-op housing in the way that I've already described. And they never, when they were in office, did anything serious to advance affordable housing in the country. That is something I think that can't be overlooked. So all of these things, Mr. Chair, present me with questions about the Conservative approach. I've said they've been sincere in raising motions, but as I talk here, as I think about it, as I further consider it, there are holes in the approach. I mean, how serious can you take an approach that says, let's have the same old meeting time and again that we've already had in the middle of a housing crisis, when we know that that type of meeting is not going to do anything to provide strong recommendations that can move us forward in the kind of way that we need to see. Just today, actually, Mr. Chair, I'm not sure if you've had a chance to see the news, but it was announced that universities can actually now take out low-interest loans. It is great news. My colleague, Mr. Couto, I don't know if you picked it up on the microphone, Mr. Chair, and he has, I talked about municipal experience on the part of colleagues. He has provincial experience that, again, can be put to good use if we're serious about allowing members
Point of order,
to
Mr. Chair.
carry out the work of committees.
We have a point of order. Clearly state the point of order you're calling it under.
My friend and colleague has strayed quite a bit here, I think, from the point of his amendment. And I wonder if maybe we could rapidly move along so we can get to a vote.
That's out of order. He was staying on co-op housing. He's been talking about housing. Oh, well, okay. Stick to.
Only. Here's the thing. You can't
Order. Mr. Fragaskatos, you have the floor.
I appreciate that.
Keep your comments to housing.
I was just saying,
As
Mr.
you were
Chair,
doing.
sometimes you can't win in this business. I was simply trying to compliment colleagues across the way, and I suppose that's how it is. That's fine. I've got very thick skin. So, I am keeping in the scope of what's been proposed. Again, just in case colleagues have forgotten what exactly the amendment is all about. Canada is in a housing crisis. So again, to Mr. Aitchison, who said that I didn't embrace that. No, I think that we have what I just described and what the amendment looks at, what the amendment recognizes. That the committee undertake a study of co-op housing and affordable housing. Well, how could we actually have a serious study of housing if we didn't look at those things? And I said, and I opened it up to committee members. I opened it up to committee members to say if they wanted to look at non-market, the importance of non-market housing, if they wanted to look at the importance of rent geared to income housing, to be more specific than what the original amendment on my side proposed, then I would be open to a sub-amendment to that effect. If committee members want to go down that path, then that's quite fine with me. But I have a hard time understanding, Mr. Chair, how we could actually have a serious meeting when, we would bring back the minister again to share with us the many actions that the government is taking to address the crisis at hand, which I would like to hear, of course. I think opposition members should hear, because oftentimes they overlook that or are not aware of it, I'm not sure. But the meeting with the interim CEO is not something that, and I think Mr. Long has something to add on these points as well, so I won't belabor the point. But I don't see how the bringing the interim chair here will do very much.
Mr. Long, before the current minister has been here twice since his appointment. Twice. Mr. Long, you have the floor on the amendment, and Madame Chabot. Yes. Mr. Long, on the amendment.
Thank you, Chair. It's great to be back in Ottawa. It's great to see all my colleagues. And I obviously respect MP Aitchison and MP Gray and Falk and Frary on their work in HUMA. The motion that MP Gray put forth, I'll be honest, you lost me with C. No housing has been built as a result of the Housing Accelerator Fund. I think that, to be fair on that one, the minister has gone across the country. He's probably signed 32 agreements so far. I think anyone that understands the Accelerator Fund is going to realize that there hasn't been housing built yet. I mean, that's accelerating the process. It's breaking down barriers. Obviously, municipalities have to, submit a plan that they're going to build so many houses over so many years. If they do that, if they achieve those goals, they'll get money. It's a wonderful program, and I was actually thrilled to have the Prime Minister in my riding here 2 weeks ago, and we made an announcement for St. John Rothsay, which was received very, very well by the community. We announced $9.2 million for the City of St. John. In addition to that, we announced $4.9 million for the Rapid Housing Initiative. And, when I started with HUMA, and happy to say I'm probably the ranking member here. I've been on HUMA since 2015. We did travel across the country at that point. Adam Vaughan was Parliamentary Secretary to Housing. I learned a lot from him, and we came up with a national housing strategy. And I think that it's puzzling to me that a federal government that is trying to lead in housing through, rapid housing, co-investment, different programs through CMHC, that all of a sudden we seem to own every problem that's happening across this country in housing. I think we all know that this has been an issue that's been unfolding over many, many years. Multiple levels of government. How the province has gotten away with not leading on this file is shocking to me. I think we are delivering, and I think that obviously, like my colleague MP Fragascato said, we do have a crisis, we do have an issue. There's been a lot of things happen, whether it's labor, whether it's supply chain, whether it's been the pandemic. And again, this has been unfolding over many, many governments, many different levels of government over many, many years. So I'm proud of what we've done. I think that Mr. Fragascato's amendment is fair. Minister Fraser, as we all know, handles himself very, very well when he's here. I've been here again for 9 years. I understand the reasoning of bringing officials in so the opposition can ask questions and maybe get a good clip or a misstep or what have you. But I think there's good work being done. I think there's productive work being done. It's not, we're not going to solve this problem obviously in a year, but I'm really, really proud of what we're doing. Chair, how are we on time?
30 seconds.
I'd like to move to adjourn, Chair.
Point of order, Mr. Chair. I said point of order before you had the gavel.
The gavel went down.
Yeah. I think we need to, I said point of order before they, before you.
It is.
You do
it
not
is-
have consent to
It is
adjourn.
5:30, and I do.
You do not have consent to
I-
adjourn, Mr. Chair.
I
Point of
do
order.
not see consensus to extend beyond 5:30. Do we have consensus to move beyond 5:30?
Mr. Chair.
Meeting adjourned.
Thank you.